The busy hallways of the Manhattan Municipal Court resounded with hurried footsteps as Sarah Bennett hurried through security. Her dark blazer fluttered behind her, and her briefcase, crammed with student papers, threatened to spill at any moment. As a 32-year-old constitutional law professor at Yale, she rarely found herself running late, but today was different. A last-minute faculty emergency that morning had forced her to cover a colleague's First Amendment lecture, and the timing couldn't have been worse. She had precisely 20 minutes to make her appointment for a parking violation hearing. The courtroom of Judge Richard Wilson was known for its strict punctuality. At 58, with gray temples and wire-rimmed glasses, Judge Wilson had built a reputation for running his traffic court with military precision. As Sarah quietly pushed through the heavy wooden doors, she noticed the sharp glare of the judge following her movements. Case number 247, the court clerk called out just as Sarah found her place in the pew. Her heart sank. It was her case. She approached the bench, trying to maintain her composure despite being out of breath. The harsh fluorescent lights cast deep shadows across Judge Wilson's face as he looked down at her citation. His expression hardened when he noticed her slightly disheveled appearance. "Miss Bennett," he began, emphasizing each syllable with barely concealed disdain. "You're 15 minutes late to your hearing. Do you consider your time more valuable than the court's?" Sarah opened her mouth to explain, but Judge Wilson raised his hand, cutting her off. The other attendees shifted uncomfortably in their seats. A young law clerk in the corner glanced up from his paperwork, sensing the tension. "Your vehicle was parked in a restricted zone for over 3 hours," Judge Wilson continued, shuffling through the papers in front of him. "The standard fine is $250, but considering your blatant disregard for court schedules and the repeated nature of this offense." He paused, his pen hovering over the citation. Sarah stood quietly, her hands clasped in front of her. Years of academic training had taught her to read rooms, to grasp the delicate balance of power and perception. She could see the assumptions being made, the judgments forming. The young law clerk continued to watch, his expression a mix of concern and curiosity. He noted how Sarah kept her dignity despite the judge's increasingly condescending tone. "I am imposing a fine of $500, Judge Wilson announced, his voice carrying an air of finality. "Perhaps this will serve as a reminder about the importance of following both parking regulations and court schedules." A murmur rippled through the courtroom as some observers exchanged glances, recognizing the unusually harsh penalty for what was usually a routine infraction. Sarah remained still, her expression neutral, although her fingers tightened around the handle of her briefcase. As Judge Wilson prepared to move on to the next case, Sarah took a small step forward. "Your Honor," she began, her voice clear and measured, "I would like to request permission to present a brief legal argument regarding this fine." The judge's eyebrows raised slightly, and a faint smile of amusement crossed his face. "Very well, Miss Bennett," he said, leaning back in his chair. "But I should warn you, this court follows established legal precedent, not personal opinions about fairness." Little did he know, he was about to receive one of the most profound lessons of his judicial career. Sarah Bennett stood confidently before Judge Wilson's bench, her posture straight despite the courtroom's tension. The fluorescent lights cast a harsh glare on her wire-rimmed glasses as she began her argument. "Your Honor, I'd like to reference the Supreme Court's recent decision in Thompson v. City of Detroit regarding municipal parking ordinances," she began, her voice clear and unwavering. The young law clerk's eyes widened as he recognized the case citation. Judge Wilson's expression shifted from mild amusement to slight irritation. He had not expected a simple parking violation to turn into a constitutional law discussion. "Miss Bennett, this is a simple parking violation. The fine stands at $500, he said, dismissing her argument. Sarah pressed on, undeterred. The Thompson case specifically addresses the constitutional limitations on punitive municipal fines. The court ruled that disproportionate penalties for minor infractions could violate due process rights. The courtroom grew unusually silent. Even the usual shuffling of papers and low murmurs ceased. Attorneys waiting for their cases began watching with growing interest as Sarah methodically presented her argument. Judge Wilson's fingers drummed impatiently on his desk. Miss Bennett, while I appreciate your enthusiasm, this court has procedures to follow. Your fine remains at $500, and I suggest you pay it promptly to avoid additional penalties. Just then, an older attorney in the gallery stood up. Marcus Rodriguez, a respected municipal law expert with 30 years of experience, cleared his throat. Your Honor, if I may? Judge Wilson nodded reluctantly, recognizing the veteran lawyer. I believe Professor Bennett's argument warrants consideration, Rodriguez stated, emphasizing Professor. Judge Wilson's eyebrows furrowed slightly as he looked at Sarah with newfound uncertainty. Yes, Your Honor, Rodriguez continued. Professor Sarah Bennett from Yale Law School. I believe you cited her paper on constitutional constraints in municipal governance in your ruling last month on the City Plaza case. A visible change came over Judge Wilson's face. Color rose slightly in his cheeks as he recognized the name. He had indeed referenced her work, considering it a brilliant analysis of modern constitutional applications in local governance. The young law clerk, now frantic, pulled up Sarah's academic profile on his phone and showed it to his colleague, who whispered something that spread around the courtroom. Judge Wilson adjusted his glasses, suddenly looking uncomfortable. The same woman he had been dismissing and fining excessively was a leading constitutional scholar whose work he had praised in his own rulings. Professor Bennett, he said, his tone now notably different, perhaps we should review the specifics of your case more thoroughly. Sarah maintained her professional demeanor, a subtle smile at the corners of her mouth. The other attorneys in the room exchanged knowing looks, recognizing the dramatic shift in the judge's attitude. Thank you, Your Honor, she replied calmly. I would appreciate the opportunity to present my full argument regarding the constitutional implications of discretionary fining in municipal courts. The atmosphere in the courtroom had transformed completely as Professor Sarah Bennett began her detailed presentation. Her voice carried the confidence of someone accustomed to lecturing in Harvard's largest halls, but retained an accessibility that kept even non-lawyers engaged. Your Honor, if we examine the constitutional framework surrounding municipal fines, she began, pulling out a small notebook from her briefcase, we find 3 key Supreme Court decisions that directly address the issue at hand. Judge Wilson had noticeably shifted his posture, now leaning forward with genuine interest. Gone was his previous dismissive attitude, replaced by the attentiveness of a fellow legal scholar. The young law clerk had abandoned all pretense of other work, furiously taking notes of the unexpected masterclass. First, let's consider Martinez v. California, 2022, Sarah continued, not referencing any notes. The court established that municipal fines must maintain proportionality with the offense. A $500 fine for a first-time parking violation, when the standard fine is $250, raises serious questions about proportionality. Several attorneys in the gallery had pulled out their phones, quietly looking up the cases she cited. The court reporter's fingers flew across her keyboard, capturing every word of what was quickly becoming an extraordinary legal discourse. Furthermore, Sarah pressed, the recent Williams decision emphasized that courts must consider the context of violations. My delay today was due to an emergency faculty meeting at Yale Law School, where I had to cover a constitutional law lecture. This context speaks to both intent and circumstance. Judge Wilson removed his glasses, cleaning them thoughtfully. The entire court could see him reconsidering not just the case before him, but perhaps his own approach to justice. The irony was not lost on anyone. Here was a judge being schooled in constitutional law by someone he had initially dismissed. Marcus Rodriguez, the veteran attorney who had spoken up earlier, watched with barely concealed satisfaction. He had seen many cases of bias in his 30 years of practice, but rarely such a clear demonstration of its unraveling. The Supreme Court has consistently held, Sarah continued, her voice steady, that judicial discretion in municipal cases must be exercised within constitutional boundaries. This includes avoiding any appearance of arbitrary or capricious decision-making. A young law student sitting at the back row recorded every word in her notebook. This was the kind of real-world legal education that no classroom could provide, watching a brilliant legal mind challenge authority while educating everyone in the room. The court officer, who had seen thousands of cases, stood slightly straighter, sensing that he was witnessing something significant. Even the usual rustling and murmuring had completely stopped. The room was absorbed by Sarah's masterful presentation. Judge Wilson finally spoke, his tone markedly different from before. "Professor Bennett, your argument regarding proportionality and context is compelling." He paused, carefully choosing his next words. "Would you be willing to share some thoughts on how municipal courts might better balance efficiency with constitutional considerations?" Sarah's expression remained professional, but a slight smile touched her eyes. This was no longer just a traffic court hearing. It had turned into a scholarly discussion between legal minds. The power dynamic had shifted, not through confrontation, but through intellectual authority. "Certainly, Your Honor," she replied, opening her briefcase again. "I recently published a paper on this very topic in the Yale Law Journal. The key lies in developing standardized criteria for discretionary decisions while maintaining flexibility for unique circumstances." The young law clerk had filled several pages with notes, recognizing that he was witnessing an event likely to be discussed in legal circles for years. This was justice and education working hand in hand, transforming a moment of bias into an opportunity for growth. The courtroom had become an impromptu legal symposium as Professor Bennett continued her presentation. Judge Wilson, who had started the session with stern authority, now sat in respectful attention. "Your Honor," Sarah said, retrieving a small tablet from her briefcase, "I'd like to share some relevant statistics from my recent research." She activated the screen, revealing a detailed chart of municipal fine distributions across different demographics over the past 5 years. "Our study of 10 major metropolitan areas showed concerning patterns in discretionary fining," she said, moving her fingers gracefully across the tablet as she spoke. "We found that identical violations often resulted in significantly different penalties based on factors unrelated to the offense itself." The young law clerk, who had been taking detailed notes, suddenly recognized the research. It was the groundbreaking study causing waves in legal circles for months. He nudged his colleague, whispering excitedly about witnessing its author in person. Judge Wilson cleared his throat. "Professor Bennett, I believe I reviewed this study in the Harvard Law Review last month. The implications for judicial reform are significant." His voice carried a note of humility that surprised the regular court attendees. Sarah nodded, continuing her presentation. "What's particularly relevant to today's discussion," she said, "is our finding on fine escalation. When we controlled for all other factors, the probability of receiving an increased fine showed troubling correlations with non-legal variables." Marcus Rodriguez watched with satisfaction as several other judges who had wandered into the courtroom listened intently. Word quickly spread through the courthouse about the surprising turn of events in Traffic Courtroom 3. "But most importantly," Sarah continued, her voice clear and even, "the Supreme Court's recent Davidson ruling emphasized that municipal courts must provide clear justification for any fine that exceeds standard penalties. This requirement acts as an essential safeguard against arbitrary decision-making." A court reporter from the local law journal had slipped into the back row, realizing that this seemingly routine traffic court session had turned into something worthy of publication. Her pen moved rapidly across her notepad, capturing every word. Judge Wilson adjusted his glasses, looking more thoughtful by the second. "Professor Bennett, your research suggests we need more structured guidelines for discretionary fines. Could you elaborate on how such a system might function in practice?" Sarah responded immediately and thoroughly. "Certainly, Your Honor. We've developed a matrix of objective criteria that courts could apply to ensure consistent and fair discretionary fines." She pulled up another document on her tablet. "This framework has already been adopted in 3 state court systems, with promising outcomes." The young law student in the back, who had been recording everything, realized she was witnessing history in the making. This was no longer about a parking ticket, it was about real-time evolution in judicial practice. "The key," Sarah explained, her passion evident, "is to maintain judicial discretion while setting clear objective parameters for its exercise. This protects both the court's authority and the citizens' rights." Judge Wilson nodded slowly, his earlier irritation entirely replaced by professional respect. "Professor Bennett, would you be willing to share your research findings with our Judicial Training Committee?" I believe your insights could benefit our continuing education programs. The transformation was complete. What had started as a routine traffic court hearing had evolved into a masterclass on constitutional law and judicial reform. The power of knowledge had overcome prejudice, and everyone in the courtroom knew they were witnessing something remarkable. Sarah smiled warmly. I would be honored, Your Honor. In fact, I'm scheduled to give a lecture series on this very topic at the Judicial Institute next month. Perhaps we could begin there. The courtroom remained silent and attentive, waiting for Judge Wilson's response. The morning had become a powerful reminder that justice is most effective when guided by knowledge, understanding, and a willingness to learn, even for those who sit in judgment. News of what had transpired in Traffic Courtroom 3 spread like wildfire through the courthouse by lunchtime. The building's marble corridors buzzed with whispered conversations about the professor who had turned a simple traffic hearing into a landmark moment for judicial education. Jennifer Martinez, a senior court administrator who had slipped into the courtroom midway through Sarah's presentation, sat in her office reviewing the morning's events with colleagues. In 20 years working in this system, she remarked, I've never seen anything like it. Meanwhile, Judge Wilson retreated to his chambers, his usual lunchtime routine forgotten, as he pored over Professor Bennett's published works on his computer. His secretary noticed how he had pulled out past rulings, comparing them with the constitutional framework Sarah had presented. Did you know? He called out to his law clerk, still frantically organizing notes from the morning session, that Professor Bennett's methodology has been cited in over 30 federal cases this year alone? His voice carried a mix of admiration and lingering embarrassment. In the courthouse cafeteria, Sarah sat with Marcus Rodriguez, the veteran attorney who had helped identify her credentials. Several other lawyers had gathered around their table, eager to discuss the morning's events and learn more about her research. The beautiful thing, Sarah explained, stirring her coffee thoughtfully, is that this isn't about pointing fingers or assigning blame. It's about improving the system for everyone. Her words carried the same measured wisdom that had captivated the courtroom earlier. Outside the courthouse, local legal bloggers were already crafting headlines. Yale professor turns traffic court into constitutional law seminar and routine fine leads to breakthrough moment in judicial education. The story was gaining traction quickly in legal circles. Back in the courtroom, the afternoon session was about to begin, but something had changed. Judge Wilson's demeanor was noticeably different as he addressed the new cases before him. Each fine and each decision was now preceded by a clear explanation of the reasoning behind it. The young law student who had witnessed the morning's events had already emailed her professor about the experience. Today, I saw the real-world impact of legal scholarship, she wrote. It wasn't just about winning a case. It was about changing perspectives. Sarah's phone buzzed continually with messages from colleagues and former students who had heard about the morning's events. The dean of Yale Law School had already reached out, suggesting they develop a new course focused on practical applications of constitutional theory in municipal courts. Judge Wilson's secretary watched as he rescheduled his afternoon appointments to allow time for reviewing the court's fine structure. Get me the statistics for all discretionary fines issued in the past year, he requested, his voice carrying a newfound sense of purpose. In the courthouse library, 3 judges from other divisions huddled around a computer, pulling up Professor Bennett's recent publications. The morning's events had sparked a conversation about their own practices and the need for continued learning. Sarah had returned to Yale, walking into her afternoon class to find it unusually full. Word had spread, and students from other departments had come to witness the professor who had turned a traffic ticket into a teaching moment. Today, she began, addressing her eager students, we're going to discuss something that happened in traffic court this morning. More importantly, we're going to talk about how legal theory and practical justice intersect in everyday situations. The courthouse staff, from security guards to file clerks, shared the story of how a seemingly routine moment had transformed into something extraordinary. Many noted how Judge Wilson, known for his strict demeanor, had shown that true judicial authority comes not from rigid enforcement, but from a willingness to learn and adapt. By the end of the day, what began as a simple traffic violation had become a catalyst for change. The incident demonstrated how education, respect, and open-mindedness could transform not just a single case, but potentially an entire system of justice. The young law clerk, finally finishing his notes from the morning session, smiled as he added one final observation. Today, justice wasn't just served. It was taught. The following morning brought unexpected developments to the courthouse. Judge Wilson arrived earlier than usual, carrying a thick folder of Professor Bennett's published articles. He had studied late into the previous night. His usual stern expression had been replaced by one of thoughtful contemplation. As he settled into his chambers, his assistant handed him an envelope that had just arrived from the State Judicial Review Board. Inside was a formal letter requesting his participation in a newly formed committee on equitable justice in municipal courts. The timing could not have been more fitting. Meanwhile, Sarah's morning lecture at Yale was interrupted by a call from the American Bar Association. They wanted her to deliver the keynote address at their upcoming conference on judicial reform. Transforming Traffic Court, a case study in constitutional application, the caller explained. What happened yesterday has already become a talking point in legal circles across 3 states. We believe your experience could help shape new guidelines for municipal courts nationwide. Back at the courthouse, Judge Wilson sat in his office with District Court Chief Justice Eleanor Martinez. "Richard," she said, reviewing the previous day's transcript, "what happened in your courtroom yesterday wasn't just about a traffic ticket. It was about the evolution of our entire judicial approach." The young law clerk who had witnessed everything was now tasked with compiling a detailed report of the incident for the court's training department. As he worked, he couldn't help but smile at how a simple traffic violation had snowballed into something that might reshape judicial training protocols. In the courthouse cafeteria, veteran attorneys gathered at their usual table, but their conversation was anything but ordinary. "Did you hear?" one asked. "Judge Wilson has requested a complete review of all discretionary fines issued in his court over the past year." Sarah's inbox filled with emails from law professors across the country requesting permission to use her traffic court experience as a case study in their classes. One message, in particular, caught her attention: an invitation to contribute to a new textbook chapter on practical applications of constitutional law. The courthouse security guard who had witnessed Sarah's rushed entrance the previous day now told the story to anyone who would listen. "You should have seen it," he said. "She turned that whole situation around with nothing but knowledge and grace." Judge Wilson spent his lunch hour drafting a formal letter of apology to Professor Bennett. His words carefully acknowledged not just his hasty judgment of her case, but also the larger implications of unconscious bias in the justice system. "Dear Professor Bennett," he wrote, "yesterday's proceedings in my courtroom served as a powerful reminder that justice is best served when we remain open to learning and growth. Your handling of the situation was both masterful and enlightening." In the law cafeteria, Sarah overheard students discussing her traffic court experience. One young woman turned to her friend and said, "That's why I want to be a lawyer, to make change happen, even in places where you least expect it." The court reporter, who had transcribed the previous day's proceedings, found herself being interviewed by the local legal newspaper. It was remarkable, she recalled, watching how a potential conflict transformed into a teaching moment that benefited everyone in that room. By late afternoon, Judge Wilson had initiated 3 significant changes in his courtroom procedures, implementing a standardized fine review process, establishing clear documentation requirements for discretionary decisions, and introducing a new system for considering contextual factors in traffic violations. Sarah received a surprise visit from her department head at Yale. "We're thinking of developing a new practical law clinic based on your experience," he explained. "Something that bridges the gap between academic theory and courtroom reality." The young law student who had witnessed everything turned her detailed notes into a blog post that was now circulating widely in legal education circles. How a traffic ticket taught us about justice had already received thousands of views. As the day drew to a close, both Sarah and Judge Wilson reflected on how a simple parking violation had become a catalyst for change. Their paths would cross again soon, but this time as collaborators in the pursuit of more equitable justice. The courthouse janitor, cleaning Judge Wilson's courtroom that evening, noticed the judge's demeanor as he left for the day. Sometimes, the janitor thought to himself, The biggest changes start in the smallest places. 1 week after the transformative traffic court incident, changes were already evident throughout the municipal court system. Judge Wilson stood before a packed auditorium at the state judicial conference, sharing the podium with Professor Sarah Bennett in what had become the most anticipated session of the year. Last week, he began, his voice carrying a humility that surprised his longtime colleagues. I learned that sometimes our greatest teaching moments come when we least expect them. The audience, composed of judges, lawyers, and legal scholars from across the state, listened intently. Sarah sat beside him, dressed in a navy blue suit, her presence commanding respect. The previous week's events had sparked a movement neither of them had anticipated. Local news outlets had picked up the story, and it had resonated far beyond the legal community. What began as a routine traffic violation, Judge Wilson continued, exposed deeper truths about our justice system. He gestured to a screen behind him, where statistics from Sarah's research were displayed. Professor Bennett's research demonstrates that unconscious bias can impact even the most well-meaning judicial decisions. In the audience, the young law clerk who had been present during the original event sat with an open notebook, just as he had that memorable morning, but now he wasn't alone. Hundreds of other legal professionals were doing the same, eager to learn from this unexpected partnership. When it was her turn, Sarah approached the podium. Change, she began, often arises from uncomfortable moments, but our response to these moments defines our dedication to justice. Her words carried the same thoughtful wisdom that had transformed Judge Wilson's courtroom. The courthouse had undergone its own transformation. New guidelines for discretionary fines were posted in every courtroom, and training sessions on implicit bias were scheduled for all court personnel. Even security guards had undergone additional training on respectful interactions with all visitors. During the conference break, Sarah found herself surrounded by judges eager to discuss implementing similar reforms in their own jurisdictions. Your experience, said one judge from a neighboring county, has made us all rethink how we handle routine cases. Meanwhile, Judge Wilson had become an unexpected advocate for judicial reform. His recent rulings showed a clear shift toward more contextual consideration of circumstances, and his colleagues took note. Some even joked that it had become the Bennett effect. At Yale, Sarah's constitutional law class had doubled in size. Students packed the lecture hall, drawn by her real-world application of legal principles. Theory becomes practice, she told them, sometimes in the most unexpected places. The local bar association established a new committee on judicial equity, with both Sarah and Judge Wilson serving as founding members. Their first task was developing guidelines to standardize discretionary fines across all municipal courts in the state. The original $500 fine imposed by Judge Wilson had been formally vacated, but its impact continued to ripple through the legal system. The incident had become a case study in judicial training programs across the country, showcasing how bias could be confronted and corrected in real time. During lunch, Sarah shared a table with several other legal scholars. The beauty of what happened, she explained, is that it wasn't about confrontation but about education and growth. Her colleagues nodded in agreement, recognizing the wisdom of her approach. Due to overwhelming interest, the conference organizers added an extra session to their presentation. We never expected this level of engagement, the program director admitted. Clearly, this story has struck a chord. Judge Wilson's closing remarks captured the spirit of the transformation that had swept the legal community. A week ago, I thought I was simply enforcing the law, he reflected. Today, I understand that true justice requires constant learning and self-reflection. As the conference ended, Sarah learned that her traffic court experience would be included in next year's constitutional law textbooks. The incident had become more than a story. It was now a teaching tool for future generations of legal professionals. The young law clerk, still taking detailed notes, watched as Judge Wilson and Professor Bennett concluded their presentation. In his notebook, he wrote what would become the title of his own future article, How 7 Minutes in Traffic Court Changed the Face of Justice. The day ended with an announcement. The state Supreme Court had approved funding for a new judicial training program focused on practical constitutional applications in municipal courts. Its first instructors were Judge Richard Wilson and Professor Sarah Bennett. 1 year after the landmark traffic court event, Judge Wilson stood in his newly renovated courtroom, preparing for a special ceremony. The space had been transformed, not only with new technology and modern furnishings, but also in the spirit of how justice was administered. Professor Sarah Bennett entered the courtroom, now a familiar and respected figure, carrying a copy of her newly published book, Justice in Practice: Transforming American Courts from Within. The foreword had been written by Judge Wilson himself. Today, Judge Wilson addressed the gathered crowd. We celebrate not just changes in our court system, but a fundamental shift in how we view justice. The audience included judges, lawyers, academics, and even some people who had been present that fateful morning a year ago. The young law clerk, now working at the district attorney's office, sat in the front row. His detailed notes from that day had become part of a mandatory training module for all new court employees. Sometimes, he whispered to his colleague, the most important lessons come from our biggest mistakes. Sarah stepped up to the podium, her presence as commanding as ever. When I walked into this courtroom a year ago, she began, I never imagined it would lead to nationwide reforms in municipal courts. The statistics displayed on the new courtroom screens told the story. Discretionary fines had become more equitable, case reviews more thorough, and public trust had significantly improved. The courthouse had become a model for other jurisdictions, with visitors from across the country coming to observe the new procedures implemented after what became known as the Bennett incident. Every courtroom now displays clear guidelines for discretionary decisions, and regular bias training is mandatory for all staff, Sarah continued. Our story has never been about a single fine or a single court appearance. It's about the possibility of transformation when we approach challenges with openness and wisdom. The audience nodded, many having witnessed this transformation firsthand. Judge Wilson's reputation had changed completely. Once known for his strict adherence to rules, he was now celebrated for his balanced approach to justice. His recent appointment to the state Supreme Court's Ethics Committee reflected this evolution. The ceremony also included the unveiling of a new plaque outside the courtroom, reading, Justice Through Understanding, dedicated to continuous learning and equitable treatment for all. Below this were the words of that memorable traffic court session. Sarah's book had become required reading in law schools across the country. Her chapter on the traffic court incident, titled 7 Minutes That Changed Everything, was especially popular among students studying practical constitutional law. The local law school had established the Bennett Wilson Fellowship, supporting research on judicial reform and practical constitutional applications. The first class of fellows sat in the audience, eager to continue the work that had begun with a simple parking ticket. Looking back, Judge Wilson reflected during his speech, what seemed like a challenging moment became the greatest teaching opportunity of my career. His words carried the weight of genuine transformation, moving everyone in the room. The courthouse staff organized a small reception after the ceremony. As people mingled, sharing stories and experiences from the past year, it was clear that the changes went far beyond new procedures and guidelines. Sarah found herself talking to a group of new judges. Remember, she advised them, every case that comes before you is an opportunity to either reinforce or challenge your assumptions. Choose wisely. The local bar association presented both Sarah and Judge Wilson with their annual Justice Innovation Award. The citation read, for transforming a moment of potential conflict into a catalyst for positive change in our judicial system. As the ceremony drew to a close, a young law student approached Sarah. Professor Bennett, she said, your experience showed me that one person really can change the system. Sarah smiled, recalling her own thoughts from that morning a year ago. Judge Wilson's final words captured the spirit of the day. What we learned here goes beyond legal precedent or judicial procedure. We learned that true justice requires both wisdom and humility, and that every day presents new opportunities to learn and grow. The courthouse janitor, who had witnessed the original incident, watched the proceedings with satisfaction. Amazing, he thought, how the smallest moments can lead to the biggest changes. As the sun set on this landmark day, Both Sarah and Judge Wilson knew that their story would continue to inspire change in courtrooms across the nation, proving that justice, when guided by wisdom and understanding, could truly serve all people equally.